If you've been in a car accident in Tennessee, you're probably dealing with two problems at the same time. Problem one is obvious. You're hurt. Your car is damaged. You're missing work. You're stressed about bills. Problem two is the one nobody warns you about. The insurance company is already working on a story that pays you less. And here's the scary part. That story gets stronger every day you wait. Every document you misplace, and every time you say something harmless like, "I'm fine." I'm Tennessee attorney John Griffith. In this video, I'm going to walk you through 5 practical secrets that can dramatically increase your car accident injury settlement. So let's jump right in. Secret 1, building your evidence file in the first 24 hours. If you want a stronger settlement, you need a stronger file, and the strongest files start early. As soon as you're safe, document everything. Take photos and videos of all vehicles from multiple angles, the interior of your car, including airbags, seatbelts, the road, skid marks, debris, and the intersection traffic lights, signs and visibility issues, your injuries, even if they seem minor. Why does this matter? Because your case usually turns into a question of proof, not pain. Insurance companies love gaps. If you don't have photos, they can guess the damage was minor. If there's no witness name, they can assume you changed lanes. If you wait a week to document bruising, they can claim it came from something else. Also, get the other driver's information: name, phone number, insurance, and plate number, and a little legal detail that matters. Tennessee law requires drivers involved in crashes to stop and exchange information and render reasonable aid. That's part of why getting names and details at the scene is so important. Look at Tennessee Code annotated 5510-101 and 5510-103. Those rules exist for a reason. Now, here's a simple but powerful move most people skip. Write down what happened while it's fresh in your mind. Not tomorrow, not after you've talked to 3 friends and your memory has blended with their opinions. Write down where you were coming from and where you were going, your speed and lane, what the other driver did, what you saw and heard, anything the other driver said to you at the scene. A quick example, I've seen cases where the other driver apologized at the scene, then later told the insurance company that they had the right of way. If you wrote down that apology they gave you immediately, it's harder for them to rewrite history. Finally, start a pain and limitation journal. Keep it simple. Every day, please note your pain level, sleep problems, headaches, dizziness, or numbness, missed work hours, things you cannot do normally. That journal becomes a map of your life before and after the crash, and it makes it much harder for someone to call your injury minor. Secret number 2, do not settle fast just because they act nice. The first offer is usually not a fair offer. It's an early exit route. Insurance adjusters are trained to call quickly, sound helpful, and get you to accept money before the full picture is clear. Here's why that's dangerous. A lot of injuries do not fully show up on day 1. Neck and back injuries can worsen over days. Concussions can be missed early. Shoulder injuries can seem like soreness until you try to lift, work, or sleep. If you settle early and sign a release, your case is usually over, even if you discover you need more treatment later. Now let's talk about the Tennessee clock, because this is where people panic and make bad decisions. In Tennessee, most personal injury claims have a 1-year statute of limitations. That's at TCA 283104. 1 year goes fast, but the solution is not to rush into a cheap settlement. It's to protect your case early so you have time to understand your injuries, gather records, and negotiate from strength. A good settlement is built on complete information: diagnosis, treatment plan, medical bills, future care needs, lost wages, how your life changed. If you don't know those numbers yet, you don't know what to demand. So if someone is pushing you to wrap this up, ask yourself one question: why are they in such a hurry? Because it's not to help you, it's to save them money. Secret 3, consistent medical treatment is not optional. If you want top dollar, you need a clean medical history. That means 2 things: get checked out, follow through. Insurance companies attack cases with treatment gaps. They love gaps. If you wait 2 weeks to see a doctor, they argue you weren't really hurt. Something else caused your pain. You made it worse by waiting. If you start treatment but miss appointments, then they argue you must have been feeling better, or your injury wasn't serious. You didn't do your part. Here's the truth most people don't want to hear. The insurance company does not measure your injury by your suffering. They measure it by documentation. So be consistent. Go to your appointments, follow the plan, take medication as directed, do the physical therapy if it's prescribed, and keep copies of everything: bills, prescriptions, mileage to appointments, doctor's notes, work restrictions, time missed from work. Also, tell your doctor the full truth about your symptoms, not the "I'm tough guy" version. If you say "I'm okay" and your chart says you're okay, you just handed the adjuster a weapon to use against you. Now, I know what you're thinking. What if I can't afford treatment? That's a real concern, but don't use that fear to do nothing. Talk to an attorney. In many cases, we can help you find medical providers who will treat you with payment deferred until the case resolves, depending on the situation. The goal is simple: a consistent medical timeline that clearly connects the crash to your injury and your injury to real-life consequences. Secret 4, stop giving the insurance company free ammo. One of the fastest ways to shrink your settlement is to talk too much. The other driver's insurance company will often call and ask for a recorded statement. They'll act like it's routine. They'll act like it's required. It's not. Their job is to find anything that reduces value or shifts blame. That statement will never help you. That can be as small as, "I'm feeling better today. I didn't see them until the last second. I'm not sure if my signal was on. I might have been going a little fast." These words get saved, replayed, quoted, and used against you to argue comparative fault or exaggeration. Here is what you say instead. Calmly and politely say, "I'm getting medical care. I'm not giving a recorded statement. Please contact my attorney." Then stop talking. Also, a warning about social media. After a wreck, do not post about your injuries, your activities, the crash, how you feel. Even an innocent photo at a birthday party can be twisted into, "They're fine." The insurance company is building a file against you. Do not help them build it. Secret 5, use Tennessee rules to your advantage, not against you. This is the part most people underestimate. Tennessee has specific legal rules that can make or break a settlement. And if you don't understand those rules, you can accidentally negotiate your case like it's worth less than it is. Here are 3 big ones. First, fault rules. Tennessee follows a modified comparative fault system. In plain terms, if you're found 50% or more at fault, you recovered nothing. If you're less than 50% at fault, your recovery can be reduced by your percentage of fault. This is why evidence matters so much. Photographs, witnesses, crash reports, and a clear story do not just help, they protect you from getting blamed. Second, the seatbelt myth. A lot of people think, if I wasn't wearing a seatbelt, I'm done. Not necessarily. Tennessee Code Annotated 559604 limits how seatbelt non-use can be used in a civil case, and it has specific conditions and exceptions. The point is, do not assume you had no case. Get legal advice based on the real facts. Third, deadlines. Remember, Tennessee Code Annotated 283104 is 1 year. If you wait too long, you lose leverage. Evidence disappears, witnesses vanish, and you can get boxed into a bad outcome. This is why working with an experienced Tennessee car accident attorney can change the result. Not because a lawyer has a secret number, but because a good attorney builds the evidence file like it's going to trial, calculates damages correctly, including future costs, documents lost wages properly, handles medical liens and subrogation issues, negotiates from strength, not desperation, knows the local patterns of insurers and defense tactics, and sometimes the biggest value jump happens for one simple reason. When the insurance company knows you are prepared to file suit and prove your case, their offers change. If you remember nothing else, remember this: big settlements are not magic. They are built. They're built with proof, with medical documentation. They're built by protecting your words. They're built by refusing to settle blindly. They're built by understanding Tennessee deadlines and fault laws and rules. So here are your 5 secrets in 1 line each. Document everything fast. Do not settle until you understand your injuries. Treat consistently and follow the plan. Do not hand the insurer a recorded statement or social media ammo. Use Tennessee rules and a Tennessee lawyer to protect your value. If you're dealing with a car wreck injury in Tennessee and you want to know what your case is really worth, the safest next step is a consultation before you sign anything or give any recorded statement. Talk to a Tennessee car accident attorney who will evaluate the facts, protect your timeline, and help you make decisions that keep your options open. Now, if you found this video helpful, hit that like button and subscribe to this channel for more content that will help you or someone you know protect themselves, find justice, and get every penny owed. Thanks for watching. See you on the next one.